The Cuyahoga County Operations and Intergovernmental Relations Committee for Tuesday, May 31st, 2016 will be called to order, and the clerk will call the roll.
Calling the roll, Mr. Miller.
Here.
Ms. Simon. Here. Mr. Brady. Here. Mr. Germana. Here. Mr. Greenspan. Here. We have a quorum.
Thank you very much. Has anybody signed in for public comment?
No, Mr. Chair, no one has signed in.
Thank you very much. And the next item on the agenda is the approval of the minutes from the April 5th meeting. Do I have a motion relative to those? Is there a second?
Second.
It has been moved and seconded to approve the minutes for the April 5th, 2016 meeting. Is there any discussion? Hearing none, all those in favor say aye. Aye. Any opposed say no. Ayes have it, and the minutes are approved. And next we have item number 5, matters referred to the committee. One item, ordinance 2016-0010. Ms. Christina.
Ordinance 2016-0010, amending section 205.06 of the Cuyahoga County Code to modify the appointment process for the chair of the Debarment Review Board, the qualifications for members of the board, and to provide that all members of the board shall serve without compensation.
Thank you very much. That item is now before us, and the proposed ordinance was introduced by Ms. Simon on behalf of the Debarment Review Board, so I'm going to call upon Ms. Simon to explain why the legislation is needed.
Sure. Thank you very much, Mr. Chair and committee members. This amendment comes out of the Debarment Review Board, and just as a bit of history, the Debarment Review Board was established in conjunction with our ethics code and our debarment ordinance, and allowed for debarred contractors to be able to appeal to a body and have the ability to state their case, why they shouldn't be debarred. When we first had the wave of debarment letters go out, there was quite a bit of activity at that time initially. And there was a lot of, one large hearing, I wasn't on the board, past President Connolly was on that board, and made a determination at the time that it would be very valuable to have a retired judge on there and to make sure that the members were lawyers and that the members were compensated because of the work that was involved with at least one or two of the major hearings. So since that time, however, there was a retired judge was appointed, and it became clear throughout this last 12 months, 6 months, that a sitting judge who was retired, or anybody for that matter, could not sit on the board and collect their PRS. So there was a lot of complications with a compensated board member and being able to be retired as a PRS retiree. So the notion was then to make that position perhaps non-compensable, but that creates problems as well with PRS. So it was determined at the debarment board that nobody should be compensated. And it's not only for a particular person or a particular judge, it's to allow this this board to have qualified retirees, because that's exactly the pool of people from which we would like to have serve on there: retired judges, former litigators, people who have been in the public system who would be really valuable members to be able to serve. But so that comes with it, that the trade-off, and nobody on the debarment board has an issue with nobody being compensated. So that expands the pool from which to select members of the board and hopefully a retired judge. And we also made some qualifications in the amendment for every board member has to be a lawyer. They have to be in good, standing. They have to have 5 years of experience. So we opened it up and just said lawyers, but non-compensated. So that's the rationale. That's the history. And the debarment board is all on board with not being compensated, and that will really allow us to have a strong board going forward.
Okay. Questions by my colleagues? I have a question, and as I read the legislation, it seems like it also changes the way that the chairperson of the board is chosen. Is that correct?
Yes. Yeah, and well, there's initially, or as it stands now, it's administrative judge. And we don't think that's necessary to have that happen. It's more, now we're bringing it here to the executive with council confirmation.
Okay. Any other questions?
And just as a follow-up, it might not be a judge. You know, the next chair of the committee doesn't have to necessarily be a judge, I don't think, does it? Yeah, so it didn't make sense really to just outsource that to the administrative judge anymore.
Okay. Yes.
How often does this debarment review board meet?
We meet monthly. Without any, we've been working very assiduously on coming up with a well-set, formulated rules and coming up with everything of every procedure, and it helped to have the former judge on there to really establish us as a board of appeals. And we meet every month, and it's been a lot of work, but not a lot of hearings coming in. But what we really envision ourselves, hopefully at some point, with other appeals processes throughout the county, that this would be an established board going forward, maybe, because we've worked so hard to give us this legitimacy and experience, and I think a really good set of rules to hear appeals, evidentiary rules, procedural rules, all of those things that have to be addressed in the Court of Appeals, but we've made a Court of Appeals board. So we've met a lot, but I'm not sure we're going to continue to meet because we have everything pretty well down pat now. If this passes, and we'll just be ready to hear hearings, and hopefully down the road when we have administrative appeals with other kinds of cases, instead of not only the debarment, we'll be able to hear these appeals as an already established, pretty well-versed body.
So I understand most of this has been administrative in getting it set up and
well, initially, Councilman Germana, there were hearings after the first wave of debarment letters went out to contractors, and that was a few years ago. But since then, it is pretty much setting up, since I've been appointed, and I think I'm in year 2, we've worked on these types of issues.
So these are just people that or companies that are appealing debarment. So I'm just wondering, do you have an idea of the numbers of appeals that have been?
There's only been a couple of appeals, okay. And it's after how many? 2, right? Okay. So they get notice.
I was just trying to get a feeling.
So they just had 2 several years ago, and since then it's been somewhat relatively quiet.
Okay. Thank you very much.
I have one further question, which is that as far as the 3 additional members who are not the chairperson and are not the council member appointee, it appears that the qualifications have been significantly narrowed, where previously they could have experience in contracting law, arbitration, prior service on public boards, or other kinds of experience, but we're narrowing it to that they have to be attorneys at law in good standing, and I'm wondering why you feel that that's necessary.
Because that's really how this board is functioning as akin to a court of appeals, and what the issues that come before the court are usually appellate issues and legal issues. It's not a question of fact necessarily, but we think lawyers are really important to have at this level, especially down the road if we think that this is going to be used, which I hope it is, for other appeals, to have this board set up. I think it's a legal process. It's a legal process. It's not issues of, so that's why.
And when you say this board could in the future handle other kinds of appeals, can you give a few examples of what those might be?
Well, any kind of, we have an administrative set of procedures and rules now and different departments. It's not going to be HR. They have their own obvious PRC. Go ahead. Mike.
Thank you, Mr. Chair. This is probably it's not something that's currently pending before council, but probably a good example would be a couple of years ago there was some legislation introduced related to the Consumer Affairs Department that imposed additional penalties if and when the county decides to start regulating the general public or imposing civil penalties in some form or another. You have to provide due process. You can't take something away from somebody or impose that type of penalty without giving them a chance to be heard and a chance to respond. So what most either municipal or local or even state or federal governments do is they provide an administrative process by which you can be heard. And that's exactly what we did here with the Department Review Board. So again, there's nothing currently in the pipeline. Everything's sort of still being talked about conceptually, but this is, I think, the type of vehicle that could potentially be used to expand the subject matter jurisdiction of the board and provide that due process.
So it could expand beyond simply being the Department Review Board to a broader appellate type board for county decision making.
And that's one of the reasons why we thought it would be prudent to have lawyers instead of somebody specifically knowledgeable about an area. And the department is, you don't need a contractor experience. It's more legal analysis, I think, even specific to this board. But moving forward, we hope to have this as really just an established board akin to a court.
And is there any urgency on this legislation where it would need to be passed under suspension, or would the 3 readings?
3 readings are good.
Be good. Any other questions? Hearing none, would you like to make a motion to refer to the full council for second reading?
Yep, so moved.
Second.
Moved and seconded to refer ordinance number 2016-0010 to the full council for second reading at the June 14th meeting. Any further discussion? Hearing none, all those in favor say aye. Aye. Any opposed say no. Ayes have it. It's carried unanimously. Is there any miscellaneous business? No? Anybody signed in for other public comment?
No, Mr. Chair, no one has signed in.
Okay, I would just mention that I think one or more charter amendments could get introduced on June 14th at the next council meeting. I would expect that those, if we follow the process that we've had in the past, that those would be referred to this committee and we would have an initial hearing on them, after which they would be forwarded to the committee of the whole. Mr. President.
Mr. Chairman, I'm sure that because you mentioned it to me earlier, but not in the context of this, that since we're going to cancel the second meeting in August this year, unless something happens we really don't expect, just make sure to be mindful of it, because normally that might be the last date. I don't actually know that, but that would seem to, I know in August is usually the last date for putting something on the ballot, so I'm sure you are mindful of it, but I just wanted to mention that we might have to have a little bit of a shorter takeoff.
I appreciate that, and actually I prefer there to be 2 shots at a charter amendment, because it requires 8 votes, and you might have a meeting where 1 or 2 members are absent, which makes it very difficult. So I would actually like to see charter amendments be ready to be voted upon at the last meeting in July, with the first meeting in August as the fallback date. Yeah. Mm-hmm. Okay. Anything else? Hearing none, I'll make the motion to adjourn. Is there a second?
Second.
All those in favor say aye. Aye.
Aye.
Opposed? Thank you very much, everybody. Okay.
Oh.